and talking about evidence of flight. In our case, we have a situation where defendant was incarcerated for several months at the county jail after the alleged crime in question, and escaped from that facility, was charged with a new felony, convicted, and sent to prison on it. And I think, if nothing else, you look at the time period involved, and I think the probative value of any flight related to the reason why we're here is very tenuous. And I think it would be prejudicial to allow that, given that it is very tenuous, to allow it into a trial and have the jury focus on something that isn't really relevant. And I think it's prejudicial, and I don't think the prosecution needs that to present their case, given the proofs as we anticipate it. As the prosecution pointed out, there was a confession in this case that we assume is going to come into evidence, and the question, I think, is going to hinge on, we don't dispute there was a confession, we don't dispute that there was a killing. The question is, what does that amount to? In large part, that's going to relate back to intent at the time, not 3 or 4 months into the future, when somebody's incarcerated at a county jail and decides that they're going to escape from that facility. So this isn't a situation where somebody's escaping from the scene of the crime that we're on trial for.
In the case before the court, Mr. Koenig doesn't link the escape to this crime, but in fact, he was in jail, held without bond for the homicide at the time he scaled the fence. And I would put on the witnesses to say that he scaled the fence. The jury instruction does give the cautionary instruction, does give cautionary language, so the jury will not focus on the escape being an element of the crime. It would simply use that as one more of our bolstering pieces of evidence to show the defendant's state of mind. His state of mind the time he killed Anaya Mack is an issue. His state of mind subsequent to his killing of Anaya Mack when he jumped the fence will also be an issue. So we're asking the court to allow the people to put on relevant evidence that is not unfairly prejudicial.
The pertinent and relevant evidence to show defendant's possible state of mind is that he fled or attempted to flee soon after having been charged with the incident offense. The government is limited to presenting evidence on this and only this point at trial. For the reasons I just stated, the defendant's motion in limine to preclude the mention of the defendant's escape conviction is denied in part and granted in part.